All rise. The Court of Appeals Division 1 is now in session.
Okay, you may be seated. This is the time set for argument in our case number CACV 200537, Naumann et al. Versus Benefit Strategies. Each side will have 20 minutes for argument. Counsel for appellant will be responsible for reserving any time you'd like for rebuttal. These proceedings are being audio and video recorded. So if you could identify yourself and your client when you approach the podium for the first time, that would be helpful. We have read the briefs. We've conferenced this case. We hope we're familiar with the facts and the arguments that have been raised, and we look forward to hearing from you. And without counsel, you may proceed.
Thank you, Your Honor. Daryl Wilson on behalf of appellants Roger and Cheryl Naumann, both as trustees and Roger Naumann as a beneficiary of the plan. Roger and Cheryl Naumann are owners of the Second Home Pet Resort. It's a small business located in the West Valley. A few years ago, they opted to set up an employee benefit plan, which included a pension plan. The pension plan would benefit their employees, but also benefited Roger Naumann directly, who is as a beneficiary because he's also an employee and a plan participant. The plan was adopted by the Naumanns and the Naumanns as trustees, and the Naumanns contracted as trustees with appellees, as third-party administrators of the plan. The appellee's duties primarily consisted of running calculations and sending notices. After approximately 3 years, the Naumanns discovered that the plan was significantly out of balance and that the contribution calculations provided by the appellees were grossly incorrect. The original estimate when it was reported to the IRS and Department of Labor was that the plan would need an infusion of approximately $400,000 to correct the plan being out of balance. The impact, it also the improper calculations also impacted Roger Naumann's anticipated tax deferred benefit and the amount of contributions he would receive back as a pension benefit from the plan. There's no dispute that the plan was formed and is under ERISA, and that the Naumanns are trustees of the plan. Roger is also a beneficiary of the plan. That's not in dispute. The contracted issue is a matter between the plan and a non-ERISA fiduciary, third-party administrator. Appellees are not named fiduciaries in the plan, and they've never claimed to be a named fiduciary in the plan, which would create a fiduciary duty under ERISA. And there's also no evidence that's been presented in the motion or prior in this litigation that the appellees performed anything that was considered a functioning fiduciary activity under ERISA. As a result, this is not an ERISA-regulated relationship. The claims asserted in the litigation do not seek to enforce terms of the ERISA plan, and the trial court erred in finding preemption of ERISA of the state law claims, relying primarily on preemption of law that preempted state law statutes or claims asserting benefit rights. As detailed in the appellant's brief, state common law claims for professional negligence, breach of contract, and breach of warranty are not preempted by ERISA.
Is it always true, Counsel?
Under these particular circumstances, it is almost universally true.
Let me focus on that almost.
Okay.
What would be preempted?
If it would, okay, if it's against a non-ERISA fiduciary, If they were functioning as a fiduciary at the time, if they were asked to perform a fiduciary function, and fiduciary functions usually mean exerting some type of discretionary authority over the plan, whether it's a denial of somebody's benefits under the plan, or it's investment decisions.
So if the claim either wasn't a state law fiduciary duty claim or akin to a state law fiduciary duty claim, your argument is that would never be.
No, if they were not, well, ERISA has its own definition of fiduciary versus state law, which makes it, fodder for confusing arguments. But a standard fiduciary under state law generally involves money and the allocation of money and holding money and so forth. And so fiduciary duty claim under a common law fiduciary claim more than likely would be preempted, but not a professional negligence claim.
So let me see if I can rephrase this because I want to, or play it back because I want to understand
Sure.
your position. Claims under ERISA are governed by ERISA, right? So we'll set those.
Correct.
A ERISA fiduciary duty claim is such a claim. Is a state common law fiduciary duty breach involving an ERISA plan, would that be preempted?
It would depend on the nature of the fiduciary breach. If it deals with money in the trust or in the fund, such as a breach by a breach by someone who had access to the funds in the plan, but an investment advisor, but the investment advisor is a ERISA fiduciary, so I don't see how that would come up. Or the trustee embezzling funds, but a trustee is an ERISA fiduciary, so I'm not sure exactly how a state fiduciary duty claim would specifically come up against a non-ERISA fiduciary under those circumstances.
So we haven't, my focus really on that question was the perhaps unique nature of a ERISA fiduciary definition, which could differ from the state common law fiduciary.
Correct.
And then sort of the rest of the universe of state common law claims in your view are not preempted.
Correct. Breach of contract claims that do not go to breach of the ERISA plan itself are not preempted.
Let me ask you about that then, because the claims, the three claims asserted in the complaint, get pretty close to the line that you've just drawn, and we're asked to determine whether they cross that line.
Correct.
That BSW breached their contract to administer the plan. Paragraph 49 talks about improper management. How is that not sort of in the ERISA milieu that you kind of described for preemption?
Because the duties that they are, the plan itself, we're talking about calculating benefits. And calculating benefits relate to the plan to the extent that the plan's involved. But it doesn't relate to it from the standpoint of ERISA preemption, because you're being contracted to provide calculations based on a formula. And that was one of the issues that came up in the Baffert case, was that, that was an administrator, similar type position, doing similar ministerial functions. And the court found that contract didn't create a fiduciary duty. It didn't pertain or didn't relate to an ERISA plan. It wasn't a breach of the plan itself. It was a breach of the obligations required to properly calculate the benefits of a pension plan. And I think that case is very clearly on point with this case, because it does relate to a pension plan and calculating the benefits under that pension plan. and a miscalculation of them. And the, as was outlined in the supplemental briefing, they're similar situated plaintiffs, non-fiduciary defendant, and it does not lead to a preemption of the state law claims. The appellees attempted to distinguish Bafford by claiming that the BSW was functioning as was doing functional fiduciary activities in this case, but that is inconsistent with what Bafford said, because there's nothing to show that they did anything other than calculate benefits and send notices. They're not a named fiduciary in the plan. That's established. And it's also inconsistent with the ruling or what they argued in federal court that's in the appendix on page 33. The BSW is a third-party administrator, TPA, performing as a TPA is well-known function at ERISA, and regarding the scope and duties is well settled, is not generally considered a fiduciary unless it is engaged in non-ministerial high-level discretionary activities. And then it states further down on the page, neither BSI or decedent was performing any such investment duties according to breach of fiduciary duty claim cannot be maintained against them. And basically they're saying that they were not that they were not performing any functional fiduciary duties. Does that address your question? Okay. If there's not any other current questions, I would reserve my time. Thank you.
May it please the court, Gary Dukrich for Defendants Appellees Benefit Strategies West and Janet Hansen in her capacity as personal representative of the estate of Janet Odenwald, deceased. I would like to go right to my best case and also update the court on a refinement to the argument, an additional citation that I would like to call to the court's attention. This is our Flanagan case, which the court has in front of it, 228 Federal Supplement 2nd, 830 at 847 to 49. And my apologies to the court for not citing it before for this purpose. We'd cited it regarding fiduciary duties, but reviewing the reply brief, the plaintiffs rightfully noted that the Flanagan case is also talking about preemption. And the Flanagan case is a good case to look at because it really draws the line between preemption and non-preemption in a case that's factually quite similar to this one. In the Flanagan case, the defendant was a third-party administrator. Let me stop and say, the third-party administrator is not a fiduciary under ERISA. We have never claimed that. That's never been the item here, neither functional fiduciary nor any other kind of fiduciary. What they are is a non-fiduciary administrator. And as an administrator, they are an important office holder under the plan. What I think the Flanagan court called an ERISA principle. In the nomenclature gets a little fuzzy because a lot of different courts approach ERISA, but that's a good a term as any. There are certain important offices under ERISA and the plan. The trustees, who are fiduciaries, are an important office. The employer, sometimes called the sponsor, is an important office. The administrator, which whether it's fiduciary or not, and usually the administrator is not a fiduciary, but it's still an important office holder under ERISA. It's an ERISA principle. ERISA treats administrators differently than it treats independent service providers. Neither an administrator nor an independent service provider is a fiduciary, and that's not the issue. But the line, which was drawn in Flanagan, shows that when the the third-party administrator is dealing with activities under the plan itself, administering the plan, as Judge Thuma was saying with my my opposing counsel, then you're going to have preemption, and that does not depend on the defendant being a fiduciary. In fact, in Flanagan, that's why it's such a good case. You see one claim is preempted and another claim is not preempted. And what the court there said was the preempted claim is where this administrator was accused of not doing its duties under the plan correctly, not administering the plan or helping the trustees administer the plan correctly. That claim was preempted. There was a different state law claim that had to do with negligent misrepresentation that occurred before the administrator was even hired or the plan was drawn up or the contract for services was brought up or drawn up. And the court there said, no, that's not going to be preempted because that's too far away. You, Mr. Non-fiduciary administrator, although you are an administrator, you were not administering the plan. You were doing something that had to do with duties that weren't under the plan, and so we're not going to preempt in that position. So Flanagan draws a really good line in a similar factual circumstance, and if you look at this case versus Flanagan, you'll see that we're on the preemption side of the line.
Counsel, let me ask you about Flanagan. That's a 2002 case from the District Court in Ohio.
Correct.
Which is located in the Sixth Circuit. We're at state court in the Ninth Circuit, and we're 19 years later, and have either the advantage or disadvantage, depending on your perspective, of some appellate court decisions from the Ninth Circuit and other courts in the 19 years that followed Flanagan. What are we to make of that?
Neither the passage of time nor the difference in circuits is really going to affect us here. There is nothing intervening in those years that draws a different line or affects the jurisprudence since Flanagan. And yes, Flanagan is a district court case. It's with a federal judge who's dealing more often with ERISA, but none of the higher courts say anything that's really different there. If you want to look 60 days ago in Bafford with the Ninth Circuit, the rule is the same. Bafford goes the other way because there the defendant was an outside service provider, not the plan administrator. And I would say, my other best case, let me lay out for the court, is Bowie. And Bowie does the same thing that Flanagan does. Bowie is a Ninth Circuit case, 310 Federal 3rd, 1143. That's also 2002, but it does the same thing. It considers claims that fall on both sides of that line, the preempted side, the non-preempted side. And it says the same thing. We quoted it in our supplemental brief. If you're talking about administration, you're looking at preemption. If you're talking about independent services that don't go to the administration of the plan, there they were evacuating an employee out of a foreign country, that's not going to be preempted. And the cases all fall along that same line. The cases that go the other way are as important to me as the cases that go my way because they draw a constant and a consistent jurisprudence that says basically along three factors. Number one, what's the identity of the defendant? Is it an administrator or is it an outside service provider? If it's an administrator, you're probably going to find preemption. If you're just looking at a non-administrator, fiduciary has nothing to do with this. Non-administrator service provider, you're probably looking outside preemption. Number two, what's the nature of the alleged defalcation? Does it have to do with administration of a plan? Does it go to something that's within the plan? In here, the defalcation, the alleged wrong, is failure to adequately fund the plan. There's nothing more core to a plan than the failure to fund it. The requirement that it be funded is right there in ERISA, 29 U.S.C. section 1028.
Counsel, is it the failure to adequately fund the plan or the failure to tell me what I need to do to adequately fund
It's both, Your Honor. Well, first, I should be clear that the third-party administrator here, my clients, didn't have the power to fund the plan.
Right.
And the wrongdoing they're talking about is their alleged failure to tell the trustees how to fund the plan. But the actual claim here is, in the well-pleaded complaint here, the claim is against the trustees. The trustees failed to fund the plan adequately. Now, the trustees can then turn to the administrator and said, yes, but you told us wrong. And of course, that, in this case, would have required Mr. Naumann to sue himself, because he's both the beneficiary and the trustee.
And that hasn't happened.
And that is unlikely to happen, but that is the dispute that has to be taken up by the court that adjudicates this. What are the funding levels? Was the reliance of the trustees on first of all, did the trustees actually underfund the plan? That's a core issue of ERISA that a state court and the various different state courts are not supposed to be looking at under federal preemption. Number two, were the trustees, the plan itself essentially, in ERISA the plan can sue and be sued in its own name rather than through the trustees. Were the trustees appropriate in relying on this administrator, because the trustees are fiduciaries and the administrator is not a fiduciary? Was that an appropriate reliance? And that's a core ERISA issue. You can't decide that issue without looking at the ERISA jurisprudence and the ERISA statutes. And so what we're looking here is, even if the trustees aren't named as defendants, the trustees are at the core of the failure here. And so we're looking at those relationships. And the Baffert case is a great case, even though it goes the other way, because again, the functional facts are different there. But the Baffert case talks about the relationship that in Baffert wasn't present. Do we have a relationship between the plan and the administrator, between the plan and the employer? Those are all the relationships that are present here.
In Baffert, counsel, isn't it true that plan and administrator is not one of those preemption, those connection with test relationships that the Ninth Circuit traditionally looks to?
The administrator is, Your Honor, one of those personnel. It is the office holder that is looked at for ERISA.
So where in Baffert, what's the citation, the pinpoint cite to an officer in the Baffert case, where they're talking about the relationship to the officer, this non-fiduciary person who still can't be sued under ERISA and also can't be sued under what you're describing as an administrator?
The Baffert pin site is, have to start with, the pin site is at page 1031 to 1032, and I have a quote for you. In Baffert, expresses it in the negative, saying that in Baffert it was missing. And what it says is Baffert says plaintiffs, those are the beneficiaries. Beneficiaries' claim against service provider Hewitt do not here bear on the relationship between beneficiary plaintiffs and the plan, or between employer Northrop, the administration committee, and the plan, or between beneficiary plaintiffs, employer Northrop, and the administration committee. Again, that's 1031 to 32. Here, the third-party administrator is in the same role that the committee was in Baffert. So what we have is the plan, here it's the trustees, and the administrator, there it was the committee, and the beneficiary plaintiffs. There is the relationship that Baffert complains was missing there, and it's present here. So that would be my cite. And that relationship being present here is going to give rise to preemption.
So are you saying that BSW had the power, as the committee had power, to perform fiduciary functions for the plan? Is that what you're saying?
No, not in this case.
Okay, then how are they simple?
Because the ERISA law treats administrators specially and differently.
Pursuant to the Flanagan case.
Pursuant
Is that what you're saying?
Pursuant to ERISA law itself. Administrators are called out specially in the ERISA law, in the statutes. We cite one or two of them. And the other thing that the committee there and BSW share here is that they had functions to administer the plan. Whether those functions were fiduciary or not in nature doesn't matter. The question, as Bowie points out, is whether the problem is one of plan administration or for some outside service. When you look at the service provider in Bafford, there's no equivalent person here like that. That's somebody who is on the outside who doesn't touch plan administration. The service provider in Bafford was giving some outside advice to the beneficiaries and allegedly caused the beneficiaries to make some bad personal decisions. Nothing the service provider did there touched on plan administration directly.
So the Bowie case talks specifically about a singular group of people who operate in multiple capacities inside the plan, right?
Correct.
It specifically says they wear different hats. I believe that's the language.
Correct.
Okay, so, and then it says, if I'm not mistaken, that whenever you look at the question of preemption, you have to examine which hat they were looking on when you're looking at the conduct complained of. Would you agree with that?
Correct, I would agree.
Okay, so then if someone can have fiduciary functions that would, say, be preempted, as Bowie says they can be, and then non-fiduciary functions or administrative or ministerial functions that are not preempted, then is it not possible that someone can stand as a third-party administrator and have two different functions, and then you have to look at what that difference is, right? Where's the conduct, and what hat were they wearing at that time?
With respect, the distinction is not between fiduciary, non-fiduciary, as was just posed. The distinction is between plan administration, outside services. That's the distinction in Bowie. That's the distinction in Flanagan.
So is your argument that a third-party administrator is an officer, no matter what it is that they do, no matter what hat they're wearing, they partake of the protections from state law preemption, no matter that they don't have any kind of ERISA claim against them?
I would not go that far. I would say they enjoy those, we'll call them protections from state law claims, when they're acting or when the claim lies in plan administration. If the claim lies in an outside non-administration service, as it did in Bafford, as it did in Paulson and McDowell and all those other cases, even if you're a fiduciary, if you're not administering the plan, if that's not where the problem is, where the alleged problem is, then you're not going to get ERISA coverage. But fiduciary or not, if you're administering the plan when something goes wrong, if that's where the claim is, then you are covered by ERISA and there's going to be preemption.
So the plaintiffs here, the Naumanns, have claimed that the failure to look at the plan and derive a calculation for what these contributions have been, okay, you're saying that that is core to the plan?
Correct.
Okay. And notwithstanding that there's no interpretation of the plan, there's no construal of the plan, there's no fiduciary function deriving out of that calculation, your clients don't bear any kind of, or the claims against them arising out of that are preempted because they share they occupy a function or an office as an officer under the plan, so that any claim of that nature is core to the plan.
I believe I would agree with that. I would cite that their alleged incorrect information to the trustees caused the trustees to commit a breach of fiduciary duty, and that this will, in adjudicating this claim, the plan terms and even ERISA statutes will have to be construed.
Well, isn't that the same thing that happened in Bafford, though? You have Hewitt is you acknowledge that Ninth Circuit says Hewitt is a third-party service provider, okay? they make a mistake, they look at the plan, they open up the plan, they look at the plan, and then they say, here's the calculation, and they turn it around and give that to the committee. And then the committee says, okay, well, they have the responsibility, so buck stops with the committee. And then there's a claim against the committee and against Hewitt, which is not fiduciary, and so the court says no fiduciary ERISA claim.
Again, with respect, it's not about fiduciary versus non-fiduciary. And in Baffert, the service provider, Hewitt, wasn't advising the committee, the administrator. The service provider was directly giving information or allowing beneficiaries to plug in information on their website. So there was no touch into the administration of the plan. And I think I can stop there. And by saying, regardless of fiduciary system, because the third-party service provider was not touching on administration of the plan, they may have looked at the plan in working with their bad calculations. We don't know that. But adjudication of that claim is not going to require interpretation of the plan. Here, by contrast, we are looking at what is the proper funding of this plan and what is the proper reliance of fiduciaries on non-fiduciaries within ERISA. That's the kind of thing we don't want all the states to look at differently. In Hewitt, it's an outside provider, presumably giving wrong advice to beneficiaries. The adjudication of that is not going to require interpretation of plan documents for the wrongdoing.
Let me ask you about that real briefly. How do we know that the information was wrong if you don't refer to the plan documents in the Hewitt situation?
I would say that the information from the plan is going to be relevant, but you're not going to be interpreting plan terms or ERISA law as part of the adjudication. First of all, the parties there had basically conceded for purposes of the motion to dismiss that the information was wrong. So there is a touch of the plan, and in all the cases where preemption is not found, the plan is somewhere in the background, or we wouldn't be talking about it. But what you're not doing is you're not looking at core functions by core functionaries, whether or not fiduciary, that work through the administration of the plan. In Baffert, this was happening outside the plan administration stream because it was beneficiaries voluntarily looking up information. So I'm not going to sit here and say no one's going to talk about the plan at all if Baffert goes to trial, but it's not the core line of administration versus service provider that you see in Bowie. In Bowie, too, the fact that the plan was there affected the information going on for evacuating the employee out of the country. They wouldn't have been doing it if the plan hadn't have caused them to be hired to do this work in the first place. So the plan is there, but the line that the courts have drawn is between plan administration versus outside service provision, and that's never clearer than in Bowie, which is why Bowie is one of our best cases. Thank you, Your Honors.
This is really all about the fiduciary status, whether it's being named as a fiduciary or performing a fiduciary function. The Baffert case, we've seen nothing different between what BSW or Janet Odenwald was required to do in relation to the pension plan in this case versus the pension plan that Hewitt was providing benefits for or providing services for. The court specifically found in Baffert that calculations of benefits is a ministerial function. It does not have a fiduciary duty attached to it. So thus, even if Hewitt were a functional fiduciary with respect to some of its actions, it would not have been acting as a fiduciary and performing calculations according to the plan formula. So of course the plan's always going to be there, and if you look back and you talk to you go back to some of the tests and whether it relates to and all the confusing jurisprudence that's occurred over the last, 40, 50 years since this came in, it talks about when the plan becomes so tenuous. It's not a breach of the plan. Yes, if you're going to calculate benefits, you're going to have to interpret the plan, what the plan's requiring based on formulas. The court in Baffert specifically says that that's a ministerial function. There's no discretion. This isn't a denial of benefits. In Bowie, I believe the issue was they were supposed to take action according to the plan documents to evacuate this person, and they didn't do it. So that was an actual breach of an obligation contained in the plan. And the plan was at issue. But again, we're 20-some years from Bowie. We're 20-some years and several district or circuit courts away from Ohio. And
Counsel, what do you make of the argument that because you're a third-party administrator occupies a special position, non-fiduciary though they may be, okay, that necessarily imports ERISA concerns of preemption? What do you make of that argument?
well, I haven't seen anything that in any of the ERISA statutes or any of the case law that specifically states that a third-party administrator has this special position unless they're a fiduciary. And you can assign, and part of a plan, you can make a third party be your fiduciary and make fiduciary decisions. But they're paid accordingly, they're insured accordingly, and they understand that that's what their obligations are. And this frequently comes up in health benefits. A lot of times you have a health benefit company, your health insurance company is in a fiduciary duty in determining whether or not benefits are provided for under the plan. But we don't have those issues here. The term third-party administrator kind of gets describes a lot of different things. Basically, you're an accountant. You're someone who does ministerial tasks. You don't have you're not making discretionary decisions, which is really the touchstone of whether you're doing a fiduciary function under ERISA.
But counsel's argument, if I understand it correctly, is that you don't have to perform fiduciary functions. Your status as a third-party administrator is a special place that's carved out in ERISA law, was the statement, the argument. My question to you is where is that, and what do you make of that argument?
I don't find that argument at all carved out in ERISA. I mean, they've made the argument that the third-party administrator is exempted, or the claims against, that she does not, the third-party administrator does not qualify under ERISA in federal court, specifically based on the fact that it was doing ministerial actions. And so now they're making the claim here that state law claims are preempted. So what, there's no claim? I mean, that just doesn't make any sense. In fact, this was actually addressed in Baffert, that the broad congressional purpose underlying ERISA is to protect the rights and interests of beneficiaries under the employer-sponsored plans, and depriving a plaintiff of a remedy of the wrong that they will allege without examination of the merits of the claim. Broadly, this would be inconsistent with ERISA's purpose. Why would we exempt somebody that is supposed to hold such an important position in the administration of an ERISA plan? Why would we exempt them from ERISA but then preempt any state law claims? So there's no claim against them, but they're apparently this key party that is necessary to the administration of these pension plans. Well, an exemption basically allows these individuals or entities to commit malpractice, to do whatever.
You don't read that language in Baffert as claiming that, every wrong regardless of how significant it would be, that involves an ERISA plan, entitles someone to a remedy against the court?
Well, if it's a valid state, it doesn't preempt a state law claim that would be a valid state law claim.
Well, and I understood your argument to be somewhat different than that, with respect to that specific language in BAFTA, so I appreciate that clarification.
Yeah, I'm sorry, I might have got a little.
No,
Sorry.
perhaps I misunderstood.
No. I mean, you have to have a valid state law claim, and we have limits to our state law claims. And obviously, there's some claims that the state has decided, and just Western jurisprudence in general, that not all wrongs are righted. But if they're a valid state law claim, you have to be able to assert your claim, and it wasn't the congressional intent to take away malpractice. I mean, I would argue that a lawyer has at least as much importance as a third-party administrator that calculates benefits and sends out notices when the lawyer is making, advising the trustees to whether to deny a benefit or not. Well, the lawyer isn't a fiduciary in ERISA, and there's case law cited in here that specifically says that lawyers are not, malpractice claims against lawyers are not preempted. Accountants, actuaries, they're all the same thing. They're all third-party service providers, and there's nothing that creates this special relationship of a third-party administrator, or else Congress would have put that in the act specifically. And they didn't. And the reason is probably because the federal court doesn't want to do a bunch of accounting, state law, traditional state law claims. That's what we have here.
Counsel, what of the argument that a defense to the Naumann's claims in this case is that they as trustees have actually violated the plan? Wouldn't that defense necessarily involve an ERISA, or pull in ERISA impermissibly into the case, and by doing so taint the whole thing so it all goes down together?
Well, yeah, but in Baffert, the same argument could be made that I guess would be Northrop Grumman, the administrative committee, impermissibly relied on Hewitt's advice. And so that would bring it back in. But ERISA specifically states that trustees can and are actually encouraged to hire service providers, because most of these businesses, the trustees, they don't know. They're not trained accountants. I mean, there's at least one case in here where it's a law firm, and they relied on advice from either an investment advisor or an accountant, and that caused the plan to suffer damages. So, I mean, you could always have that, like, well, yes, you're a fiduciary and you're responsible to the plan, but the Naumanns are responsible to the plan, and part of that responsibility is you would then have an indemnity claim, and they are seeking redress. They are under IRS scrutiny, and they are working on getting that resolved. But there is no current claim against them. But again, it goes back to calculations, and incorrect calculations are not a fiduciary function. They're ministerial. So the argument could be made that even if the Naumanns were calculating the amounts and then the plan ended up being underfunded, they wouldn't necessarily be doing a fiduciary function in calculating those benefits, because I believe Baffert specifically says that even if you are a named fiduciary, that doesn't, you might be doing non-fiduciary functions, and you can't be sued under ERISA for breach of fiduciary duty if you're not doing fiduciary functions. And that was, I believe, one of the reasons why the committee was dismissed on a particular count. So, the issue.
You can finish in 30 seconds here.
Okay. All right. Well, basically, thank you. I just, the case law is overwhelming that the claims are not preempted, and we request reversal of the lower court's decision. Thank you.
Thank you both for your argument. I will take this matter under advisement and issue a decision in due course. And with that, we stand at recess.
Thank you.